Good afternoon and welcome to the fifth of 10 debates presented by the City Club of Cleveland in this very important 2008 election cycle. I'm Jim Foster, Executive Director of the City Club. The City Club has a long and proud history of hosting debates for public office. Whether the race is perceived by the pollsters to be close or whether the pundits consider it to be high profile, the City Club of Cleveland provides an opportunity for those interested in their government to learn more about the issues and the candidates. And we think this is especially important for these very important races for Ohio Supreme Court. Here at the City Club, we go face to face, in person and in depth. And yes, you, the audience, and voters will get to ask questions. Many thanks to those of you who are here and those listening and watching to our podcasts and webcasts. 60 minutes will go by very quickly, so let's proceed. We are delighted to have as our moderator for today's debate, Geoff Mearns, the Dean of the Cleveland State University Cleveland Marshall College of Law. Dean Mearns has been a partner in the Cleveland offices of two prominent law firms, Baker & Hostetler and Thompson Hine. And prior to entering private practice in 1998, Dean Mearns had a distinguished career as a prosecutor with the United States Department of Justice, including service as the Assistant United States Attorney for the Eastern District of New York. Geoff?
Thank you, Mr. Foster, and thank you all for coming. I'm delighted to have the honor of moderating this debate, moderating a debate between two candidates for Justice of the Ohio Supreme Court. You know, in the state of Ohio, and as you all know, in this state, we elect our judges. All of these judicial officers, from the Supreme Court on down, they're all entrusted with a great deal of responsibility, a responsibility to make important decisions that affect our lives, our liberty, our finances, and our rights. The most powerful members of the Ohio judiciary are the 7 justices of the Ohio Supreme Court. Now, this court only resolves a relatively small number of cases compared to the very large volume of cases that are handled by the trial and appellate courts throughout the state. But the decisions of the Ohio Supreme Court affect all of us, and the impact of those decisions can last for many years. Today, 2 candidates for one of the 7 seats on the Ohio Supreme Court are here to speak to you and to answer your questions. So before we begin, let me go through the rules for the debate. For the opening portion of the debate, each candidate has a total of 10 minutes. 10 minutes for both an opening statement and then a rebuttal. And it is the candidate's choice as to how he or she will divide that 10 minutes of time. So we will hear from each candidate twice in this segment, opening statements from each, then rebuttal by each, again for a total of 10 minutes. After the opening and the rebuttal, we will move to questions from you, the audience, and then I will pose a closing question at the end of the question and answer period. Our candidates today are Maureen O'Connor, a current justice on the Supreme Court of Ohio. Justice O'Connor served as a magistrate and then as a common pleas judge in Summit County. She was then elected Summit County prosecuting attorney and then lieutenant governor of the state of Ohio. In 2002, she was elected to the Ohio Supreme Court. Her opponent in this contest is Joseph Russo, a judge on the Cuyahoga County Common Pleas Court. Judge Russo was in private practice from 1992 until 2001. During that period of time, he specialized in civil litigation. In 2002, Judge Russo was elected to the Court of Common Pleas in 2000 and re-elected without opposition in 2006. Judge Russo presently is the chair of the Civil Rules Committee. Now, before we begin, let me welcome you all again here today. And I know from looking at some of the stickers and looking at some of the table tents that many of you are here to support one candidate or the other, and that's just great. But I do have one request of all of you, that you refrain from cheering during the comments and the questions. Those interruptions will interrupt the presentation. And also it's my responsibility to tell you to stop. So please don't put me in that spot. The order of the presentation was determined by a drawing just a few minutes ago. Judge Russo will present first. Judge Russo.
Thank you very much. I am Judge Joseph D. Russo. The D stands for Democrat. I want to thank, first of all, the City Club for giving me this opportunity. I also want to thank my wife, who's out there today, Diana, who has kept our household going while I've been running across this great state, and who also had an opportunity. I don't know too many wives who would spend their 15th wedding anniversary in Dayton at an Ask Me Retirees dinner, but mine did. I also want to say something I've never been able to say before from a podium that's televised or webcasted. Hi, Mom. 28 years ago, I was here last on this stage representing St. Joseph High School in the City Club Championship debate against Brush High School with my partner, Bob Costello. I hope things fare better today. And Bob, wherever you are, this one's for you. For the first time in 38 years, the court and every justice upon it is Republican. I run on a simple message that justice requires balance. When I say balance, I mean political and philosophical balance. By political, I mean that we basically should end one-party rule with regard to this court. When I say philosophical, I believe that embracing ideas from different viewpoints and different points of view make for balanced decisions. The second problem I see in this race is that the perception of our Supreme Court has become a national embarrassment. The New York Times, in a study of our court, said that 70% of the time our justices vote with their major contributors. My opponent, and the reason I chose my opponent, was second on that list at 74%, behind only Justice O'Donnell at 91%. 83% of Ohioans polled by the League of Women Voters stated that they believe that our Supreme Court is influenced by their contributors. A Georgetown law professor called our state a rogue state that is the epitome of everything that is wrong with the judicial selection process today. Chief Justice Moyer from the Ohio Supreme Court stated that the role of money in our races for Supreme Court has exposed us to the dark side of democracy. Even the Wall Street Journal, despite a comment by the New York Times, stated that and asked the question, is justice for sale? I proposed a solution, a straightforward solution. Simply complaining about a problem isn't enough. And that solution was as follows, that rather than worrying about individual contributions, which we've already addressed in Ohio, and my opponent has stated on several occasions that my plan has been rejected by 30 states, it hasn't even been addressed by 30 states, and the only state that's actually addressed it has adopted it, that was Alabama. But the bottom line is that we weren't worried about individual contributions, we were about pooled contributions. Contributions where people got together and through one banner, let's say one law firm decided they just love me, and 100 of their people gave $1,000 apiece, and they have $100,000 contributed to the campaign, and then they expect to appear before the court. And I felt that that was a definite problem for our Supreme Court and this perception that had been raised by the New York Times. So I proposed a simple program, and that is that groups that give $10,000 or more to any justice would force the justice to disqualify themselves from the case. And I was sitting on the Ethics and Professionalism Committee for the Ohio Judicial Conference at the time I proposed this. And I proposed it, the judges from downstate loved it and said, we should lower it. We should make it $6,000 or $5,000. I said, well, I'm trying to build a canoe and you're trying to build a jet. Let's get something that we can pass and we can live with that would not be so draconian that it would cause people to have to disqualify themselves off every case. So $10,000 I felt was a fair number. I felt it was a number that we could work with and one that we could change if we thought it was an inappropriately low number or an inappropriately high number. It passed that committee unanimously, and it then went to the Supreme Court Task Force to change the Code of Judicial Ethics in Ohio. And what's happening is that the task force then changed it from a rule, which would have been mandatory, into a comment. And the comment said, instead of using $10,000, we'll call it a reasonable person standard. If a reasonable person would believe that justice had received too much money, then that justice should recuse.